Welcome to Law and Life, the Levoritz Approach.
Hello and welcome to Law and Life, the Levoritz Approach with experienced attorney Yonatan Levoritz. I am your host, Kevin Rosenquist, and today we're going to discuss family law and uncontested divorces in New York. Yoni, so great to see you again. Thanks for being here.
Thank you, Kevin, for having me.
All right, so can you explain the critical aspects of New York State's relocation laws and how they impact custody as well as visitation arrangements?
Well, in terms of affecting custody and visitation, basically what happens is there's a whole new custodial regime put in place because one parent is going to be moving or the court's going to be denying the move. Okay, if they're denying the move, then whatever the status quo is that's in place will remain in place. But assuming the move is granted, there'll be a brand new visitation schedule or access schedule, and there will be a brand new custodial regime in terms of what the court anticipates and expects people to do in terms of custody and how they intend to handle it with regard to pickup, drop off, summer vacations, holidays. It will be a whole brand new system for these parties.
We talk a lot when we talk about this sort of stuff about child's best interests. And how does New York assess the child's best interests in relocation cases, and what factors are most influential in their decision?
I would say the most influential factors are probably economic necessity or economic benefit in terms of what's going to aid the child in having a better life or support system, which is a very important factor as well. Therefore, when we're looking at the economics and when we're looking at the support system, the court is going to be most likely inclined to allow a move when there's a real reason for it. For example, let's say you just want a house with a backyard. Courts are not going to want to disturb the status quo just because, I'm making this up, of course. In Brooklyn, you end up with a backyard which is mostly cement. And in Nassau County, you end up with a large backyard with a big play place and a trampoline. Okay, they're not going to judge cases like that. They're going to look to balance the equities between the moving parent, the non-moving parent, and of course the child, and trying to make sure that the best interests of the child are furthered by the prospective move.
Yeah, that's a good distinction because I have a 4-year-old and he would love that trampoline and that we have a yard. It's small, but he would be happy with it. But that's not what we're talking about when we're talking about child's best interests.
No, when we're talking about child's best interests, we're really looking at, for example, economic necessity. You can't get a job in a particular place. The non-custodial parent is not paying child support, or they're paying nominal child support. And you really have the ability to go ahead and get a much better position or a much better job in this alternative place. So they're going to be looking not only at the ability to go ahead and get the place, such as affordability factors maybe, but they're definitely going to be looking at the economic necessity of the move. If someone is going to be losing their job, for example, due to a relocation, okay, and they have two choices, relocate or lose their job, well, the court's going to look at the ability of the person to get another job, which is commensurate to their abilities and commensurate to their pay, to allow them to keep funding the child's life and to keep funding their existence. So they got to balance all of these factors out. I would say, when it comes to relocation, it's extremely complicated because there's so many moving factors.
What other, considerations might the court make that aren't economic?
Well, they're going to look at the ability, for example, of the other parent to go ahead and have their relationship. Are they going to get summer vacations? Are they going to get midwinter break and spring break? Are they going to get enough to balance things out so they can have enough of a relationship or a good relationship with the child? Especially if they're seeing the child for a midweek dinner and for every other weekend. If you're going to be taking that away from them, you got to be giving them something else on the other side. So they're going to be looking to make sure that this child continues to have a growing, loving, flourishing relationship with the other parent.
Yeah. When the court is considering the impact of a relocation on the non-custodial parent, what can be done to mitigate the adverse effects? Like you're talking about, like the weekly dinners and all that stuff. Like, how is there a way that they can kind of like come to an agreement on this somehow?
Well, the courts don't come to agreements. The courts make decisions, of course.
Right.
Parties come to agreements. So the chances of parties coming to an agreement in a relocation case is not necessarily very great, because many times people look at these factors, such as, mom wants to move to Connecticut because it's less expensive than Manhattan and she has the ability to get remarried. Well, one of the factors is a fresh start, okay, according to the Court of Appeals. So they're going to look at that factor, but they also have to look at what the impact is going to be for her fresh start versus the child's relationship with the non-custodial parent. It has to be balanced out. There are so many factors to be balanced out. It's very difficult for a judge to make a decision.
What are some of the common challenges in contested relocation cases?
The challenge is convincing a court that the child is going to be best served by the relocation and that there's not going to be any real detriment to the non-custodial parent. And that's a very hard thing to do, especially if you have a very active non-custodial parent, someone who's over at the Boy Scouts, someone who's coaching football, someone who's coaching basketball, someone who sees the child not only for his weekends and his holidays, but sees them on a regular basis. It's going to be very hard to convince a court to say, listen, I want to get remarried, therefore I want to move to where my husband lives, therefore I should be able to move. It's a very difficult situation. And one of the things that we try and do is we try and frame these cases in a way which is very child-oriented and very non-custodial parent-oriented. Therefore, we try and push the narrative as to what the benefits could be for the non-custodial parent. For example, he may be seeing the child every other weekend, but theoretically speaking, that's only, let's say, 4 to 6 nights per month, let's say. He's getting, let's say in a 4-week month, he's getting every other weekend, and he's getting Friday nights and Saturday nights, and maybe even Sunday nights. So maybe it's a 6-night overnight per month. Well, you take a look at that and you say, well, instead of that, we're going to be giving you the entire summer. We're going to be giving you all the winter breaks. We're going to be giving you a large chunk of the fun time as opposed to the time when you'd be doing homework and other types of things.
And how is it different if the non-custodial parent consents to the relocation, if they're cool with it, how does the overall process differ from when they do contest it?
Oh, it's a piece of cake if they're going to go ahead with the process. You go into court, you get your court order, you draft up an agreement, you put in your terms and conditions, and then at that point in time, you move forward with it. It's relatively speaking simple because the other party is satisfied with what they're getting in terms of having more fun time, which is why courts look at how often a parent is visiting or how much hardship it would cause the parent to visit. For example, there was one case where a woman wanted to move from Brooklyn to Staten Island, and Brooklyn and Staten Island are right next to each other. It was maybe going to be, a 10 or 15-mile commute, but the issue came down to traffic patterns. And since the traffic patterns were going to harm the non-custodial parent's ability to visit with the children, the court didn't allow it, just based upon traffic patterns.
That's interesting. Yeah, so they really do take a lot of different things into consideration.
A lot. There are tons of moving pieces to this puzzle.
Yeah, that's one of those things that I think most people don't, if you haven't been through it, you don't think about that aspect of things. Like, if you get divorced and you want to move and you have kids, well, it's not as simple as just selling your house and buying another one. You have so many more things to consider.
You've got that non-custodial parent, and that non-custodial parent is going to be your biggest barrier to making your move for your new husband, your new wife, your new partner, your new life in a different state. It's a very complicated situation.
If a custodial parent relocates with a child and doesn't get court approval or the other parent's consent, I'd imagine there's some legal consequences there. So what kind of consequences come with that?
Yanking you back. The court will basically say, for the most part, listen, we're going to go ahead and we're going to yank you back to where you were before, or you only have a certain period of time to move back, or the other party is going to become the custodial party. So it does happen. Now, there are times when parents allow for moves to go on and they just consent to a status quo. For example, in one of my recent cases, wife moved to Binghamton or girlfriend moved to Binghamton, and the father was okay with it for the first year or so. Then he realized all the transportation was killing him, basically. And the court said, you know what, you let this thing go. You basically agreed, to a large extent. And the court also pointed out the fact that he wasn't paying child support. He wasn't a good custodial parent. He wasn't the main custodial parent. He worked a lot of hours. So there were a lot of things to be held against him. Therefore, he ended up with the move taking place, even though the person did not seek permission beforehand.
Oh, wow. Okay. All right. So the person didn't go about it the right way, but they were still allowed to make the move.
Correct. I mean, they asked permission. I shouldn't say they didn't ask permission. I'll rephrase it in a different way. They asked permission of the father, and the father basically didn't say yes or no. He basically just allowed things to happen.
Okay.
So he acquiesced in the process.
Okay. So in that case, they didn't get in any trouble. That person didn't get in any trouble for moving without going through the courts?
She did. The court initially said after the trial was over, okay, that listen, you got to move back within, I think it was like 10 miles or 15 miles or 5 miles of the father. Okay, but the appellate court overruled that decision, which is one of my cases, and the appellate court said no, she moved there for economic necessity. She moved there because it was in the best interest of the child. She moved there because the father wasn't paying child support. She moved there for numerous reasons, which the court considered on the appellate level to be good reasons, even though the trial court did not consider them to be good reasons.
Okay, that's interesting. So what options are available to a non-custodial parent who opposes the relocation? Like how can they effectively present their case in court?
Well, we see in the traffic pattern case, you present the traffic patterns and you say, I'm not going to be able to get my dinners anymore. Kids get out of school at 3, 4 o'clock in the afternoon. I'm supposed to pick them up at 4 or 5 o'clock in the afternoon. I'm not going to be able to make it there during rush hour. Therefore, she shouldn't be allowed to move. Okay. In some cases, it could be that simple. In other cases, they could present the fact that, listen, there's no real reason for the move. It's not like you're getting remarried. It's not like there's an economic benefit. It's not like you're suffering economically where you are. It's not like there's going to be a tremendous savings of money to go ahead and support the children better or to offer them a better lifestyle or any of these things.
If a custodial parent is maybe say in an apartment or something like that, and they have an opportunity to move into a better situation that's maybe bigger, that's nicer, that's a better situation for the child as far as the home is concerned, is that taken into consideration or is that not really part of it?
Depends upon the court. For the most part, the case law says you should not judge suburbs versus city. And a court should not go ahead and engage in that type of analysis. You know, whether children are better off in Manhattan or they're better off in Brooklyn or they're better off in Nassau or Suffolk, you know, the court should not really engage in that type of situation. Now, if it comes down to education, because some of these boroughs have horrible educational systems, that the court may delve into because that's for the betterment of the child.
Sure.
So instead of looking at certain areas where they don't have as good a school, you look for an area with a great school and a great school district.
Does crime play in? Can you use that one?
I have used it in the past, not successfully for the most part. It's a difficult thing to prove. It's a difficult thing to go ahead and work with. But there are other things to use in terms of neighborhood decency and everything else. That's why when we're doing these agreements, we try and put in a provision, which is not necessarily binding, but most courts will go ahead with it, called a relocation provision. And that relocation provision basically says, you can move 20 miles, you can move 40 miles, you can move 60 miles. And the parties agree to it at the very beginning of the litigation, basically, before it comes down to you saying, listen, I want to move.
Yeah, that makes sense. I imagine that every relocation case is different, or a lot of them are different. How do you develop a custom strategy for each individual case? What do you look at? What kind of questions do you ask?
It's not so much the questions asked, it's so much of looking at the person's motives in doing it. And what those motives offer for the child. Is the person who's coming into you very child-focused, very child-centric, or are they looking to do this for themselves? Because if they're looking to do it for themselves, chances are, I wouldn't say 100%, but there's a significant chance that it's going to be held against them, unless it's something like the relocation case based upon losing your job.
Right.
Okay. Or you have the ability to get a very large income as a result of moving because you're being offered a better job. Okay. Therefore, you could be a little less child-centric or a little less child-focused. But what you really have to look for is you have to look at how the impact is going to be looked at by the judge and by the court itself. Because if you're not going to focus in the client on the issues at hand, and they're just going to say, well, I need more room, well, then get a house closer by that has more room.
Right.
Okay, or live in a little bit cramped situation. But we're not going to take away rights from the other parent just because of the move. That's why we typically offer things like saying, oh, we'll split the transportation, or we'll pay for the transportation, or we'll even do the transportation. And we try and work things out to try and make sure that we look like we're the giving parties as opposed to the taking parties.
Okay, so you can do that where the person moving could offer to bring the child to the non-custodial parent.
Sure, absolutely.
Okay.
We do it all the time.
Yeah, that makes sense. That would be then you can kind of counteract the traffic pattern situation that you went over before, right?
Well, yes and no. There it's a matter of timing also, because the dinners took place at certain times of day.
Okay.
Therefore, even if the mother was to arrange for transportation, she would be doing the traffic pattern in the opposite direction, yes, at first, but then she'd be coming back in rush hour.
Mm.
And how much do we want to burden the children for her wanting to move?
Right. That's a good point. That's a good point. For anyone listening who's a custodial parent that would like to move, that would like to relocate, what advice would you give them? What steps should they take to ensure compliance with New York's legal standards?
First, I would tell them is do not take self-help. Do not go ahead and move on your own, because once you're settled into this new place, it's going to be very difficult to get yourself out of that situation. I would also tell them to look at the facts of the case and see whether or not they have the ability to make an argument that the other parent is not living up to their part of the bargain. For example, there was a case out of Queens where the father wasn't visiting, so the judge said, hey, you're not visiting. Why should we bother this woman? He contested the move. He did not want the move. But since he wasn't paying real support and since he wasn't doing what he was supposed to be doing, the court said, make the move, do it. So I would tell them they really have to look at these things very carefully. And they should always seek the advice of counsel before doing anything.
Now, that's great advice. Thanks, Yoni. Well, thanks for tuning in to Law and Life, the Levoritz Approach with experienced attorney Yoni Levoritz. For more information or to connect with Yoni, you can visit levoritzlaw.com. And of course, be sure to hit that like and subscribe button and leave us a review in the comments. Yoni, always great to talk to you. Thanks for being here.
Thank you for having me. Talk to you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.